when things sound really good for gun owners in court, that doesn't mean it's over.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Saying setting a higher threshold in an emergency could mean life or death.
This case could reshape how far states can restrict your right to carry.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
The Supreme Court just quietly added 2 additional Second Amendment cases to this Thursday's conference docket, bringing the total to 5 major gun rights cases that will be discussed by the justices, and if they grant review to even one of these challenges, we could be looking at decisions within the next 6 to 12 months that fundamentally reshape the constitutional landscape for firearms ownership across America. But here's what makes this moment genuinely historic and why gun rights advocates are calling this the final stand in the courts. One case challenges California's ban on what they call large capacity magazines, and if the Ninth Circuit's reasoning stands, it could be used to treat any detachable magazine firearm like a single-shot weapon. Another case challenges Cook County, Illinois' assault weapon ban, where the Seventh Circuit ruled that semi-automatic rifles like the AR-15 aren't protected under the Second Amendment. And 2 additional cases challenge the federal prohibition that strips gun rights from anyone convicted of a crime punishable by more than 1 year, regardless of whether that crime was violent. Once you understand why the Duncan versus Bonta case isn't new and was already sent back once in 2022, when the court told California to reconsider under the Bruin standard, but California essentially ignored that instruction, why there are hundreds of millions of so-called large capacity magazines in circulation, meaning a decision here affects far more than just one state, and what it means that multiple federal appellate circuits, including the 3rd, 5th, and 7th, now recognize that categorical gun bans must be evaluated on an as-applied basis rather than blanket prohibitions. You'll realize we're potentially weeks away from Supreme Court decisions that could strike down decades of restrictions and restore rights to millions of Americans, but only if the justices actually grant review and apply the constitutional standard they established in Bruin correctly. The courts have spent decades ignoring or significantly weakening Second Amendment protections through various legal maneuvers and interpretations, and they're about to potentially receive a heavy dose of constitutional reality. This week represents a critical inflection point. The United States Supreme Court added 2 additional Second Amendment-related cases to this Thursday's conference schedule. That brings the total number to 5 major Second Amendment cases that were already lined up for discussion this week. And if the justices grant what's called certiorari, which in legal terms means they agree to hear the case, we could soon witness decisions on some of the most contested and consequential gun laws currently in effect across the country. One of the most significant cases on the table is Duncan versus Bonta. It's a direct challenge to California's ban on what the state characterizes as large capacity magazines. Also being considered is Gators Custom Guns versus Washington. Now, the Duncan case is not new to the Supreme Court. The case first arrived at the court in 2022. At that time, the Supreme Court granted certiorari, vacated the lower court's decision, and remanded it back for reconsideration. This is what's called a GVR order, which happened after the landmark Supreme Court case New York State Rifle and Pistol Association versus Bruin. That was the decision that established the text, history, and tradition standard for evaluating Second Amendment cases. On remand back to the lower courts, a district court judge named Roger T. Benitez struck down the ban as unconstitutional once again. But the Ninth Circuit Court of Appeals reversed that decision, claiming that magazines are not arms protected by the Second Amendment. Here's where things get critical. If the Supreme Court declines to take up Duncan this time around, California's complete ban goes into permanent effect. That means owners of previously lawful large-capacity magazines, including those who obtained them during what's known as Freedom Week, could be forced to modify them, surrender them, destroy them, or permanently lose them. Many observers believe the court will take this case up because they already intervened once, essentially telling California to get its approach in order and follow Bruin correctly. But California essentially responded by doubling down on their original position. That same legal logic being used by the Ninth Circuit could theoretically be used to treat any detachable magazine firearm like a single-shot weapon, effectively gutting the foundational principle underlying modern semi-automatic firearms. Why does this matter so significantly? There are hundreds of millions of so-called large-capacity magazines currently in circulation across America. A decision upholding the ban, or even refusing review entirely, doesn't just affect California residents. It sends ripples of legal precedent nationwide, emboldening anti-gun states to pursue similar restrictions on magazines, detachable magazine firearms generally, and even broader categories of semi-automatic weapons. Another case on the Supreme Court's radar this week is Barnett versus Cook County, which challenges Cook County, Illinois' ban on so-called assault weapons. The Seventh Circuit has already ruled that semi-automatic rifles like the AR-15 are essentially the same as military-style guns and therefore not protected under the Second Amendment. They openly rejected the idea that commonly used modern sporting rifles deserve constitutional protection. If the Supreme Court takes this case seriously and applies the Bruin text, history, and tradition standard correctly, this could be the vehicle to strike down blanket bans on semi-automatic rifles across multiple jurisdictions. The takeaway here is significant. A favorable ruling could restore rights to millions of law-abiding Americans who rely on semi-automatic firearms for sport, self-defense, and the exercise of constitutional freedom. It could render decades of assault weapon bans unconstitutional, essentially overnight. On top of magazine bans and semi-automatic bans, the court added 2 more cases that challenge the federal prohibition on gun ownership by people convicted of certain crimes, even nonviolent offenses. The cases are Vincent versus Bondi and United States versus Duarte. These challenge 18 U.S. Code Section 922G1, which is the federal statute that strips firearm rights from anyone convicted of a crime punishable by more than 1 year in prison. This includes nonviolent felonies in many jurisdictions. According to the petitioners and their supporters, many federal appellate circuits, including the 3rd, 5th, and 7th, now recognize that under the post-Bruin era, courts must evaluate such categorical bans on an as-applied basis, meaning you can't simply ban everyone automatically from gun ownership. You have to examine each individual on a case-by-case basis, looking at the actual facts. Was it a nonviolent versus violent crime? What's the individual's history? What danger do they pose to the public? The question is whether blanket prohibition is constitutional. If the court takes one or both of these cases, we might witness the end of automatic lifetime gun ban punishments for people with old nonviolent felony convictions. Why is this a significant development? Tens of thousands, perhaps hundreds of thousands of people across this country who lost their rights under 922G1 could potentially see a path toward restoration of their constitutional rights. A favorable ruling here could theoretically put pressure on Congress to reform federal gun prohibition laws. Whether Congress would actually act is highly uncertain given current political dynamics, but it could at minimum limit the scope of such bans to align with constitutional requirements. Since the 2022 Bruin decision, the Supreme Court has instructed lower courts to decide gun rights cases under a text, history, and tradition framework, not through interest balancing tests that had previously been used. That standard dramatically changes the legal terrain for magazine bans, semi-automatic bans, and even felon gun bans. With 5 major Second Amendment cases now on the conference docket for this Thursday, including multiple magazine ban cases, a semi-automatic ban case, and 2 prohibited person cases, the Supreme Court could, over the next 6 to 12 months, set sweeping precedent that fundamentally reshapes the Second Amendment landscape across America. For gun owners, enthusiasts, and those who care about constitutional rights, this isn't merely abstract legal maneuvering. This could represent the last best chance to cement a broad, unambiguous right to keep and bear arms that's immune from the whims of anti-gun judges, bureaucrats, and politicians who seek to gradually erode those protections. This is the moment many have been waiting for. These cases have been working their way through the judicial system for years, and now they're finally before the highest court. The Supreme Court is actively reviewing these cases, and this Thursday they'll begin their conference discussions about them. That means in the coming months, the door could swing wide open for the return of millions of magazines and semi-automatic firearms to lawful owners, and potentially a genuine Second Amendment victory that protects these rights for future generations. But it's not automatic or guaranteed. The court must actually grant review. They must apply the Bruin standard correctly. They must resist political pressure and rule based on constitutional text and historical tradition. We need to stay informed and engaged. This may not just be another court fight. This might represent a defining moment for Second Amendment jurisprudence. If you believe in the right to keep and bear arms, and you believe the founders did not intend for bureaucrats to decide when citizens can exercise that fundamental right, staying informed about these developments is crucial. The Duncan versus Bonta case carries particular weight because of its history. The Supreme Court already intervened once, vacating a lower court decision and sending it back for reconsideration under the Bruin framework. That was essentially the court telling the Ninth Circuit to apply the correct constitutional standard. But the Ninth Circuit on remand essentially reached the same conclusion through different reasoning, claiming magazines aren't even arms protected by the Second Amendment. That's a breathtaking interpretation that could have far-reaching implications if allowed to stand. If magazines aren't protected arms, what else could be excluded from constitutional protection? The implications extend far beyond California's borders. Multiple states have similar magazine capacity restrictions. If the Supreme Court declines review or upholds the ban, it effectively greenlights those restrictions nationwide. But if they strike it down under the Bruin standard, requiring historical tradition to support such regulations, it could invalidate magazine restrictions across multiple jurisdictions. The Barnett versus Cook County case on assault weapon bans carries similar nationwide significance. The Seventh Circuit's reasoning that semi-automatic rifles like the AR-15 can be banned because they're similar to military weapons fundamentally misunderstands both history and constitutional text. The Second Amendment was written at a time when citizens owned the same arms as military forces. The notion that similarity to military weapons removes constitutional protection contradicts the historical understanding of the right to keep and bear arms. If the Supreme Court takes this case and applies Bruin correctly, it would need to ask whether there's historical tradition supporting bans on commonly owned firearms. The AR-15 is one of the most popular rifles in America, owned by millions for lawful purposes. Under any reasonable application of the common use standard established in prior cases, it should receive constitutional protection. The prohibited person cases raise different but equally important questions. The federal prohibition in 922G1 is extraordinarily broad, stripping rights from anyone convicted of a crime punishable by more than 1 year, regardless of whether the crime was actually violent or posed any danger to others. Multiple appellate circuits have now recognized that blanket categorical bans may not survive Bruin's requirement for historical analysis. The question becomes whether there's historical tradition supporting lifetime bans on gun ownership for all felonies, including nonviolent offenses. The historical record suggests far more nuanced approaches that distinguish between violent and nonviolent offenders and allowed for restoration of rights. This Thursday's conference will determine which, if any, of these 5 cases the Supreme Court decides to hear. Conference discussions are private, and we typically don't learn the results for several days or weeks afterward. But the decision to grant or deny review will set the trajectory for Second Amendment jurisprudence for years to come. If the court grants review to multiple cases, we could see a series of major decisions clarifying the scope of Second Amendment protections. If they decline review, lower court decisions would stand, potentially emboldening further restrictions. The stakes genuinely could not be higher for constitutional rights. That's it for today, folks. See you in the next video.